Alex here with part 141 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains a detailed disclaimer and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We go now into my motion to get the court to allow me to conduct limited discovery on the motion to modify child custody issue. I can remember a few things. The first thing that I remember was that I wanted to get copies of the mental health records once and for all. And I also recall wanting to get the CPS. There was more to the CPS reports. I was trying to issue subpoenas, and I didn't want to fall into the same trap that my ex's attorney allowed to occur last time. And so this time I went ahead and filed the motion ahead of time. And I don't recall either of these things becoming very useful in court, but I do recall going through the process of filing this motion, and I do think it's part of my docket series, so I can't skip it, and it's also going to be something that my viewers need to see, because in some states you actually do have to do something like this to open discovery during weird states of your case. Normally, I say weird because there's a normal discovery process with any ordinary lawsuit that just kind of automatically starts with a lot of these cases. But once your case is closed and you settle in Nevada, you go into post-judgment mode. And at that point in time, if you want discovery, you have to ask permission. You can't just get it, automatically open up again. So that's what we're going through with this video. I think at this point in time, we should just go ahead and go into what I have filed. Here we have the motion for leave of the court allowing limited discovery. First paragraph, standard introductory paragraph. I introduce myself to the court, indicating that I'm appearing in proper person, which means I don't have an attorney, and that I am filing a motion for leave of the court to allow limited discovery. We got a brief summary here in, I guess you could say this is the factual area. I don't know if I split it into those two sections this time, but anyway, I'm indicating that I am sharing joint legal and joint physical custody with my ex. The rules require that I seek leave of the court to conduct post-judgment discovery. I filed my motion to modify custody. I'm referencing that. I've also mentioned 3 reports to Child Protective Services that I want to become more educated on. And procedural background. Number 1, I'm asserting that I filed a motion to modify custody. And number 2, I'm asserting that I conferred with my ex on conducting discovery and that she failed to reply. Legal analysis. We go into Rule 16.21, which we've talked about a little bit in this video, or in the series. I'm sure we have, because it's what led up to the whole argument that my ex's attorney had that I should be sanctioned for not asking for leave of the court. And so now I'm doing that just to avoid that whole debacle. This is indicating that we have a basis to conduct limited discovery because CPS has informed me that there are details with regards to these charges, and I'm recognizing that parties are entitled as a matter of right to conduct pre-trial discovery, but post-judgment discovery, there's a higher potential for abuse, and for that reason you have to show good cause, which is what I'm doing here. Next assertion is that, like any exercise of discretion, the discretion to grant or deny leave to conduct discovery under the rules is not without limits. Okay, this is one of my favorite cases, Adamson v. Bowker, because in this case, a judge tried to argue that if he has discretion, or maybe it was the attorney, that he can really do whatever he wants. And the Supreme Court in Adamson v. Bowker said that, let's quote them. They said that leave to amend under the rules cannot be denied, quote, in the absence of any apparent or declared reason, unquote, and that, quote, outright refusal to grant the leave without any justifying reason appearing for the denial is not an exercise of discretion. It is merely an abuse of that discretion and inconsistent with the spirit of the rules, unquote. So in Adamson v. Bowker, they make it clear to these judges that just because you have discretion doesn't mean you can do whatever you want. And in fact, if you go at it with that attitude, what you're likely to do is you're likely to abuse your discretion. So anyway, let's continue on to the conclusion. The best interests of the child are paramount in child custody determinations. This court should desire as much information as possible in order to be as informed as possible, so as to make the best child custody determination possible. I'm asserting that the court should allow me to issue subpoenas ducus tecums to CPS regarding 3 CPS reports that were closed without investigation, and that I want to have subpoenas ducus tecums issued to my ex's, to our son's kindergarten teacher. I think that's the first grade teacher, actually. I don't think that's the kindergarten teacher. Jennifer Williams is the first grade teacher, to have her compel the disclosure of an email that she sent to my ex that triggered the filing of the CPS report. And number 3, that the court allow me to issue subpoenas ducus tecums to assist in locating any potential witnesses revealed by the eventual disclosure of details by CPS. So what I'm trying to do here is preempt the fact that CPS might give me some information that leads to the other witnesses. And so rather than have to come back to court with another motion, I'm trying to get this taken care of now by getting a provision that allows me to go after those witnesses. But I remember this gets denied, which is fine. All it's going to do is create more work for the court, and it's going to create more attorney fees for my ex, because if I get information back, because they deny this provision, I'll once again have to file a motion and go through the whole process again. So you see, there's situations like this where the court tries to say, don't file so many papers, but then based on the actions that they take, they force you to file more papers. I'm telling you, the doublespeak is just unending with the court system. Declaration. This declaration is me swearing under penalty of perjury that all the facts asserted in this motion are true and correct. And then we have the Rule 5 certificate of service indicating that I served this upon my ex's attorney. Next, there might be, so we got the motion opposition notice. Based on these check marks, I did not have to pay a filing fee. And then we have the list of exhibits here. We've got one exhibit, 2 pages. And this is an email from myself to so this is the meet and confer requirement, guys. So under the rules, when you want to conduct discovery, you have to confer with your opponent and see if you can come to some kind of agreement on, what you're going to do with discovery. That way you can put together a joint motion or a stipulation for the court rather than file a motion and use up the court's time. So this was me trying to satisfy that rule, which says that I have to confer with my opponent before actually filing this motion. So I went ahead and did that, and my ex's attorney didn't even respond anyway. Next document, we have the notice of hearing. We've gone over these a number of times in the past. Actually, no, that's the notice to set. So the notice of hearing comes after the notice to set. After you meet with your opponent in front of, it's usually like the administrative assistant. Sometimes it's not even in front of them. Sometimes it's over the phone. Once you go through this process, you will actually come up with a date and time for the hearing, and that's when you send out the notice of hearing. Typically, the person who filed the notice to set is the person who sends the notice of hearing out. Sometimes the courts do it. Sometimes the clerk does it, and then sometimes your opponent will do it. Who knows? But I've seen all of these happen in the past. In any event, I'm doing my job, which is to file the notice of hearing to let my ex know that there's going to be a hearing at this date and time. Of course, they already know this if they've participated at the notice to set, at the setting. But, you should still do it. It's a formality that's required. Here we have the Rule 5 certificate of service indicating that this notice of hearing was served upon my ex's attorney. Then we have an order declaring request for submission moot. This is an order by the judge. He has reviewed my motion to compel the disclosure of physical addresses, or in the alternative, for an order to show cause. I submitted my motion for consideration on this. So this must be me asking, in my motion, I'm asking for an order requiring my ex to disclose her physical addresses. The court notes that she disclosed her physical address in her SIR reply. Therefore, oh, he did it again, guys. Okay, so he doesn't read. Either he doesn't read or he doesn't care. In that motion, I specifically told him not to do this because if he keeps doing this, anytime my ex moves, she will not tell me where she lives. And he did it again. If you go back and read that motion, I specifically tell the judge that it is not enough to declare this moot just because she complies. You have to enter an order for a continuing disclosure, or she will keep doing it. And he still did this. So this is an appealable order, but I probably didn't bother appealing it because I've already got 2 things on appeal right now, which is not right. If you have a valid basis to appeal, file the appeal. But in any event, it doesn't matter because the new judge takes over and she takes care of this problem that this judge won't take care of. If you want to learn why he is flat wrong about how the mootness doctrine works, watch my video, Mootness Doctrine. I explain in that video that this sort of mistake that this judge is making, hopefully it's not a common mistake because it's quite inane. He should understand that when I ask for an order to continuously disclose and she complies one time, that she has not mooted out the issue because I'm not asking for her to just disclose one time. I'm asking her for her to disclose continuously. So anyway, watch the video Mootness Doctrine. I explain why this judge's approach to how mootness works is completely wrong. And then, of course, hopefully, if you guys have the same type of judge like this, you'll be able to file appeals against them when they violate the Mootness Doctrine. Had I known back then what I know now, I would have probably appealed this too and triggered another order reversing. But I didn't know for sure if he was wrong. Now I know he is because I've got a lot more experience and I've done a lot more research on the Mootness Doctrine. But at that time, maybe I didn't know that. And so for that reason, I didn't appeal this. In any event, this does get taken care of by the new judge, so I don't have to deal with it anymore. She will enter an order for my ex to continuously disclose her address. Going into the next page here, we have a certificate of mailing, which indicates that this judge mailed this document to both myself, well, actually just to me, and then he served my ex's attorney through electronic service. Going into the aftermath, I filed 2 documents. Those were both free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent hardly any time at all reviewing that motion. And in fact, I think all 3 of these documents, 15 minutes is a reasonable amount of time for my ex's attorney to put into review. So 15 minutes at the rate of $250 an hour, that's going to come to $62.50 in attorney fees for my ex. If you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.